Well, hi everyone. It is Christy, and I'm just gonna do a spontaneous live stream again. I'd actually planned to do this stream, but to read out the some of the amicus with the friend of the court filings from some people about the 14th Amendment. But as I was working out, I just finished a 2-hour workout on my bike, which is why I'm a mess. I decided, I heard the decision. I was like, I want to hear what this is all about. So I thought, it was kind of nice last time to have a bit of company as I did the read through. And so I thought I would do it again. The thumbnail for this video is wrong, I know, but my thinking was I need to get on here. I need to get the thing read out, and then I can go have a shower and I can organize the rest of my life. But if I do anything, like if I have a shower and have dinner, this isn't going to get done. So let's go. I haven't looked at this at all. I have no idea how it's going to go, but I'm going to do this the way that I've been doing these videos generally, which is to let it run. But if I see, like a footnote that's really long or whatever else, I'm going to skip that. I'm just going to do the body of the text. So our video says here like 1 hour and change, but it probably won't be that long because I will skip some things. Like I've already skipped a couple pages. So are we ready? I'm excited. Are you excited? I'm excited. Because anytime Trump loses, I'm happy. Uh, so yeah, let's just get going. It's gonna be this case was argued
before Henderson, Childs, and Pan, circuit judges. Opinion for the court filed per curiam. Per curiam. Donald J. Trump was elected the 45th President of the United States on November 8, 2016. He was sworn into office at noon on January 20, 2017, and served until his term expired at noon on January 20, 2021. At that moment, President Trump became former President Trump, and his successor, Joseph R. Biden, became president and began his own 4-year term. U.S. Const. Art. 2. 1. Although this 3. sequence is set by the Constitution, ID. Amend. XX. It did not proceed peacefully. Indeed, from Election Day 2020 forward. The government alleges that President Trump denied that he had lost his bid for a second term and challenged the election results through litigation, pressure on state and federal officers, the organization of an alternate slate of electors, and other means.
Sorry, y'all, I didn't mean to interrupt, but I think that there's a little bit of a problem with the Speechify, so I'm going to go ahead and just refresh this so that it doesn't have that sound. And hopefully once I just refresh this, it'll pick up and it'll be perfectly fine. So let's, fingers crossed, that's what will happen. Come on, Internet, you can do it. I believe in you. Come on, Internet. I'll turn off a couple other things that might also help just to reduce the CPU.
Interference in the constitutionally prescribed sequence culminated with a Washington, D.C. rally held on January 6, 2021, the day set by the Electoral Count Act. 3 U.S.C. 15A for the Congress to meet in joint session to certify the election results. The rally, headlined by President Trump, resulted in a march of thousands to the Capitol and the violent breach of the Capitol building. The breach delayed the congressional proceedings for several hours, and it was not until the early morning of January 7th that the 2020 presidential election results were certified, naming Joseph R. Biden as the soon-to-be 46th president. Since then, hundreds of people who breached the Capitol on January 6, 2021, have been prosecuted and imprisoned. And on August 1, 2023, in Washington, D.C., former President Trump was charged in a 4-count indictment as a result of his actions challenging the election results and interfering with the sequence set forth in the Constitution for the transfer of power from one president to the next. Former President Trump moved to dismiss the indictment, and the district court denied his motion. Today, we affirm the denial. For the purpose of this criminal case, former President Trump has become Citizen Trump, with all of the defenses of any other criminal defendant, but any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. 4. Background. Former President Trump did not concede the 2020 election, and in the ensuing months, he and his supporters made numerous attempts to challenge the results. Many of their attempts were allegedly criminal, A District of Columbia federal grand jury indicted former President Trump on 4 criminal counts arising from the steps he allegedly took to change the outcome of the conspiracy to defraud the United States by overturning the election results in violation of 18 U.S.C. 371, conspiracy to obstruct an official proceeding. IT, certification of the electoral vote, in violation of 18 U.S.C. 1512K, obstruction of, an attempt to obstruct, the certification of the electoral vote. In violation of 18 U.S.C. 1512 C.2, and conspiracy against the rights of one or more persons to vote and to have their votes counted, in violation of 18 U.S.C. 241. At this stage of the prosecution, we assume that the allegations set forth in the indictment are true. United States Ballistas 795, Fahrenheit 138, 149. We emphasize that whether the indictment's allegations are supported by evidence sufficient to sustain convictions must be determined at a later stage of the prosecution. The indictment alleges that former President Trump understood that he had lost the election and that the election results were legitimate, but that he nevertheless was determined to remain in power. Indictment 2. He conspired with others to cast doubt on the election's outcome and contrived to have himself declared the winner. One former President Trump's campaign and his supporters also unsuccessfully challenged the election results in several state and federal courts. 5. Indictment charges that he and his co-conspirators allegedly advanced their goal through 5 primary means. First, they used knowingly false claims of election fraud to attempt to persuade state legislators and election officials to change each state's electoral votes in former President Trump's favor. Indictment 10. For example, he and his allies falsely declared that more than 10,000 dead voters had voted in Georgia, that there had been 205. 0.
Okay, sometimes Speechify gets a little stuck on stuff, so we're just gonna have to deal. My apologies. I'll see. We'll just go.
Votes. Then voters in Pennsylvania. That more than 30,000 non-citizens had voted in Arizona, and that voting machines had switched votes from to Biden ID. At 12. Second, then President Trump and his co-conspirators organized fraudulent slates of electors in 7 targeted states, attempting to mimic the procedures that the legitimate electors were supposed to follow. Indictment 10. They then caused these fraudulent electors to transmit their false certificates to the vice president and other government officials to be counted at the certification proceeding on January 6. Third, then President Trump and his co-conspirators pressed officials at the Department of Justice to conduct sham election crime investigations and to send a letter to the targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome. Indictment 10. Fourth, then President Trump and his co-conspirators attempted to convince then Vice President Mike Pence to use his ceremonial role at the January 6 certification proceeding to fraudulently alter the election results. Indictment 10. When the vice president rebuffed them, he stirred his base of supporters to increase pressure on the vice president. CID at 10D96-100. Ultimately, on the morning of January 6, 2021, he held a rally in Washington, D.C., where he repeated knowingly false claims of election fraud to gathered supporters and directed them to the Capitol to obstruct the certification, proceeding and exert pressure on the vice president to take the fraudulent actions he had previously refused. Attendee. Fifth, and finally, from the January 6 rally, thousands of his supporters, including individuals who had traveled to Washington and to the Capitol at direction, swarmed the United States Capitol, causing violence and chaos that required the Congress to temporarily halt the election certification proceeding. At 10, then President at 10, 121. He and his co-conspirators exploited
All right, that's getting a little bit ridiculous. Let me see if I can change the speed. Maybe that'll help. Also, I hate to say this, I'm going to try a white male voice and see if that makes a difference. Because sometimes these AI things are a little bit racist. I appreciate them trying. But yeah, all right. Well, let's try Henry here. Okay. See if Henry doesn't has fewer problems.
Exploited the disruption by redoubling efforts to levy false claims of election fraud and convince members of Congress to further delay the certification. At 10 Then President Trump's efforts to overturn the election results were unsuccessful, and the Congress certified the Electoral College vote in favor of President-elect Biden. Indictment 123. On January 11, 2021, 9 days before President-elect Biden's inauguration, the House of Representatives adopted an impeachment resolution charging then-President Trump with incitement of insurrection, H.R. Res. 24, 117th Cong. The single article of impeachment alleged that he had violated his constitutional oath faithfully to execute the office of President of the United States, his constitutional duty to take care that the laws be faithfully executed, by inciting violence against the government of the United States. At 2. The impeachment resolution asserted that President Trump repeatedly issued false statements asserting that the presidential election results were the product of widespread fraud and should not be accepted by the American people or certified by state or 7. Federal officials, ID. At 2-3, that his statements on the morning of January 6 encouraged and foreseeably resulted in lawless action at the Capitol, ID. At 3, and that he attempted to subvert and obstruct the certification of the results of the 2020 presidential election by other means, including by threatening a Georgia state official into manipulating the results, ID. At 3-4. Importantly, by the time the United States Senate conducted a trial on the article of impeachment, he had become former President Trump. At the close of the trial, on February 13, 2021, 57 senators voted to convict him and 43 voted to acquit him. See 167 Cong. Rec. S. Because 2/3 of the Senate did not vote for conviction, he was acquitted on the article of impeachment. C.I.D. U.S. Const. Art. I. 3. CL. 6. On November 18, 2022, the U.S. Attorney General appointed John L. Smith as special counsel to investigate efforts to interfere with the lawful transition of power following the 2020 presidential election or the certification of the Electoral College. Vote. A Washington, D.C. grand jury returned the instant 4-count indictment against former President Trump on August 1, 2023, and on August 20, 2023. The district court set a trial date of March 4, 2024. Former President Trump filed 4 motions to dismiss the indictment, relying on presidential immunity, constitutional provisions, including the impeachment judgment clause and principles stemming from the double jeopardy clause, statutory grounds, and allegations of selective and vindictive prosecution. On December 1, 2023, the district court issued a written opinion denying the 2 motions that are based on presidential immunity and the 2 constitutional provisions. In relevant part, the district court rejected Trump's claim of executive immunity from criminal prosecution, holding that former presidents enjoy no special conditions on their federal criminal liability. United States v. Trump. It concluded that the Constitution's text, structure, and history do not support the existence of such an immunity, ID, and that it would betray the public interest to grant a former president a categorical exemption from criminal liability for allegedly attempting to usurp the reins of government. At 12. It also held that neither traditional double jeopardy principles nor the impeachment judgment clause provide that a prosecution following impeachment acquittal violates double jeopardy. At 18-3. Former President Trump filed an interlocutory appeal of the district court's presidential immunity and double jeopardy holdings. On December 13, 2023, we granted the government's motion to expedite the appeal. An oral argument was held on January 9, 2024. Second jurisdiction. Although both parties agreed.
I'm I'm gonna guess most people aren't interested in jurisdiction. I'm pretty sure this says the court has jurisdiction, and so in the interest of time, because that seems kind of boring, because I don't think it's fine. Um, I'm just gonna skip. We can exercise jurisdiction for two reasons. Middle asphalt does not require immunity to derive from an explicit textual source. Second, the theories of immunity former President Trump asserts are sufficient to satisfy Midland asphalt under circuit precedent. I guess if you're really interested in jurisdictional legal stuff, go back. It's a free PDF. You can just download it from the internet. But the defendant dismissal of charges. We're gonna skip over this because this doesn't. Okay, let's go. What's the last paragraph? We'll read the last paragraph. There we go.
One final reason not to overread a single adjective in Midland asphalt is that there is no apparent reason to treat an implicit constitutional immunity from trial differently from an explicit one for interlocutory review. Midland asphalt certainly did not provide one. The ultimate source of our appellate jurisdiction is 28 U.S.C. 1291, which extends to the final decision of the district court. There is no basis in the statutory text to treat the denial of an explicit immunity as final, but the denial of an implicit immunity as non-final. In both cases,
oh, they're still talking about Midland. Okay, we're gonna skip. Skip. Ooh. Executive immunity. That sounds exciting. Let's just hear the last.
Accordingly, we conclude that we have jurisdiction to reach the merits of former President Trump's appeal. Third, executive immunity. For all immunity doctrines, the burden is on the official claiming immunity to demonstrate his entitlement. Dennis Furr, Sparks, 449 U.S. 2429. Former President Trump claims absolute immunity from criminal prosecution for all official acts undertaken as president, a category, he contends, that includes all of the conduct alleged in the indictment. The question of whether a former president enjoys absolute immunity from federal criminal liability is one of first impression. See Blassingame, 87 Fahrenheit. At 5, noting the unresolved question of whether or when a president might be immune from criminal prosecution. The Supreme Court has consistently held that even a sitting president is not immune. 19. From responding to criminal subpoenas issued by state and federal prosecutors. See Trump v. Vance, 140 seconds. CT, 2412. In the civil context, the Supreme Court has explained that a former president is absolutely immune from civil liability for his official acts, defined to include any conduct falling within the outer perimeter of his official responsibility. Fitzgerald, 457 U.S. at 756. Both sitting and former presidents remain civilly liable for private conduct. When considering the issue of presidential immunity, the Supreme Court has been careful to note that its holdings on civil liability do not carry over to criminal prosecutions. See Fitzgerald, 457 U.S. at 754 N, explaining the lesser public interest in actions for civil damages than, for example, in criminal prosecutions. Cf. Clinton, 520 U.S. at 704 N, noting special considerations at issue in criminal cases. Former President Trump's claimed immunity would have us extend the framework for presidential civil immunity to criminal cases and decide for the first time that a former president is categorically immune from federal criminal prosecution for any act conceivably within the outer perimeter of his executive responsibility. He advances 3 grounds for establishing this expansive immunity for former presidents. Article 3 courts lack the power to review the president's official acts under the separation of powers doctrine, functional policy. Considerations rooted in the separation of powers require immunity to avoid intruding on executive branch functions, and the impeachment judgment clause does not permit the criminal prosecution of a former president in the absence of the Congress impeaching and convicting him. 20. Our analysis is guided by the Constitution, federal statutes, and history, as well as concerns of public policy. Fitzgerald, 457 U.S. at 747. Relying on these sources, we reject all three potential bases for immunity, both as a categorical defense to federal criminal prosecutions of former presidents and as applied to this case in particular. A. Separation of powers doctrine. The President of the United States occupies a unique position in the constitutional scheme. Fitzgerald, 457 U.S. at 749. See Trump v. Mazars USA, LLP, 140 seconds, CT. 2019, 2034. The President is the only person who alone composes a branch of government. Under the separation of powers established in the Constitution, the President is vested with executive power. U.S. Const. Art. San 1. CL. Which entails the duty to take care that the laws be faithfully executed. ID. 3. And supervisory and policy responsibilities of utmost discretion and sensitivity. Fitzgerald, 457 U.S. at 750. The President's constitutional role exists alongside the Congress's duty to make the laws. U.S. Const. It is settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the President of the United States. Fitzgerald, 457 U.S. at 753-54. See also Nixon, 418 U.S. at 706. Separation of powers doctrine cannot sustain an absolute, unqualified presidential privilege of immunity from judicial process under all circumstances. Nevertheless, former President Trump argues that the constitutional structure of separated powers means that neither a federal nor a state prosecutor, nor a state or federal court, may sit in judgment over a president's official acts, which are vested in the presidency alone. 10:21. He relies on Marbury's oft-quoted statement that a president's official acts can never be examinable by the courts. Former President Trump misreads Marbury and its progeny. Properly understood, the separation of powers doctrine may immunize lawful discretionary acts, but does not bar the federal criminal prosecution of a former president for every official act. Marbury distinguished between two kinds of official acts, discretionary and ministerial. As to the first category, Chief Justice Marshall recognized that the president is invested with certain important political powers, in the exercise of which he is to use his own discretion, and is accountable only to his country in his political character and to his own conscience. Marbury, 5 U.S., 1 Cranch, at 165-66. When the president or his appointed officers exercise discretionary authority, he subjects are political and the decision of the executive is conclusive. E. At 166, their discretionary acts, therefore, can never be examinable by the courts. ID. But, Chief Justice Marshall continued, when the legislature proceeds to impose on that officer other duties, when he is directed peremptorily to perform certain acts, when the rights of individuals are dependent on the performance of those acts, he is so far the officer of the law, is amenable to the laws for his conduct, and cannot at his discretion sport away the vested rights of others. Under these circumstances, an executive officer acts as a ministerial officer, compellable to do the highest duty, and if he refuses, is liable to indictment. At 149-50, it is not consistent with the policy of our political institutions or the manners of the citizens of the United States that any ministerial officer having public duties to perform should be 22 above the compulsion of law in the exercise of those duties. Based on these principles, Chief Justice Marshall concluded that, although discretionary acts are only politically examinable, the judiciary has the power to hear cases where a specific duty is assigned by law. ID. At 166. Marbury thus makes clear that Article 3 courts may review certain kinds of official acts, including those that are legal in nature. The cases following Marbury confirm that we may review the president's actions when he is bound by law, including by federal criminal statutes. In Little v. Bahrain, the Supreme Court concluded that the president's order to a subordinate officer to seize American ships traveling to or from French ports violated the Non-Intercourse Act precisely because the Congress had acted to constrain the executive's discretion. 177-79. Chief Justice Marshall observed that the president may have had the discretionary authority to order the seizure absent legislation but had no discretion to violate the act. 77-78. Similarly, in Kendall v. United States ex rel. Stokes. The Supreme Court reviewed the official acts of the Postmaster General, the President's subordinate officer who derived his authority from the executive br. Anch, because the civil case involved the violation of a statutory require. In 1213. To find a statutory violation unreviewable, the court held, would be clothing the President with a power entirely to control the legislation of Congress and paralyze the administration of justice. At 613. Then, in Mississippi v. Johnson, the Supreme Court considered whether the state of Mississippi could sue President Andrew Johnson to enjoin him from enforcing the Reconstruction Acts, which the state alleged were unconstitutional. 71 U.S. 497-98. The court concluded that it lacked jurisdiction to issue an injunction. 23. Relying on Marbury, Kendall, and the distinction between mere ministerial duty, in which nothing was left to discretion, and purely executive and political duties involving the President's discretion. At 498-99. See also Martin v. Mott, 25 U.S. 19, 31-32. No judicial power to review President exercising his discretionary power conferred by statute. In holding that it could not enjoin the President from using his discretion, the court nevertheless affirmed the role of the judiciary in checking the other two branches of government. The Congress is the legislative department of the government. The President is the executive department. Neither can be restrained in its action by the judicial department, though the acts of both, when performed, are, in proper cases, subject to its cognizance. The Supreme Court exercised its cognizance over presidential action to dramatic effect in 1952, when it held that President Harry Truman's executive order seizing control of most of the country's steel mills exceeded his constitutional and statutory authority and was therefore invalid. The Congress had not legislated to authorize President Truman's seizure and, in fact, had refused to adopt the method of settling labor disputes. At 586. President Truman could lawfully act only to execute the Congress's laws or to carry out his constitutional duties as the executive, and he lacked authority from either source to seize the steel mills. At 587-89. As Justice Jackson explained, the court's holding invalidating the executive order was proper because the President takes measures incompatible with the expressed or implied will of Congress. His power is at its lowest ebb. At 637, Jackson, J., concurring. Based on Youngstown and Marbury, the Supreme Court in Clinton easily concluded that when the President takes official action, the court has the 24 authority to determine whether he's acted within the law. Clinton, 520 U.S. at 703. Objection may be made that Marbury and its progeny exercised jurisdiction only over subordinate officers, not the President himself. The writ in Marbury was brought against the Secretary of State, in Little against the commander of a ship of war, in Kendall against the Postmaster General, in Youngstown against the Secretary of Commerce. But as the Supreme Court has unequivocally explained, no man in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. It is the only supreme power in our system of government, and every man who by accepting office participates in its functions is only the more strongly bound to submit to that supremacy, and to observe the limitations which it imposes upon the exercise of the authority which it gives. That principle applies, of course, to a president. Further, the Supreme Court has repeatedly affirmed the judiciary's power to direct appropriate process to the president himself. Clinton, 520 U.S. at 705. The president does not enjoy absolute immunity from criminal subpoenas issued by state and federal prosecutors and may be compelled by the courts to respond. 1. We have 200 years of precedent establishing that presidents and their official. 25. Communications are subject to judicial process, even when the president is under investigation. Vance, 140 seconds. CT, at 2,427. Citations omitted. See also Clinton, 520 U.S. at 703.05. Recounting history of sitting presidents complying with court orders to provide testimony and other evidence. The separation of powers doctrine, as expounded in Marbury and its progeny, necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts, because the fact of the prosecution means that the former president has allegedly acted in defiance of the Congress's laws. Although certain discretionary actions may be insulated from judicial review, the structure of the Constitution mandates that the president is amenable to the laws for his conduct and cannot at his discretion violate them. Mark 6. Here, former President Trump's actions allegedly violated generally applicable criminal laws, meaning those acts were not properly within the scope of his lawful discretion. Accordingly, Marbury and its progeny provide him no structural immunity from the charges in the indictment. Our conclusion that the separation of powers doctrine does not immunize former presidents from federal criminal liability is reinforced by the analogous immunity doctrines for legislators and judges. Legislators and judges are absolutely immune from civil suits for any official conduct, and legislators have an explicit constitutional immunity from criminal prosecution arising from the speech or debate clause. Nevertheless, legislators and judges can be criminally prosecuted under generally applicable laws for their official acts, consistent with the separation of powers doctrine. Legislators have explicit constitutional immunity from criminal or civil liability for what they do or say in legislative. 26. Proceedings under the speech or debate clause. Tenney v. Brandhoff, 341 U.S. 367, 372, see U.S. Const. Art. I. 6, CL. 1. But outside of constitutionally protected legislative conduct, members of the Congress perform a wide range of acts in their official capacity that are not legislative in nature and so can subject them to criminal liability. Gravel Vors. United States, 408 U.S. 606, 625, CID. At 626, speech or debate clause does not privilege either senator or aide to violate an otherwise valid criminal law in preparing for or implementing legislative acts. In United States vs. Johnson, a congressman was criminally charged with conspiring to pressure the Department of Justice to dismiss pending indictments of a loan company and its officers on mail fraud charges. 383 U.S. 169, 171. The Supreme Court held that the prosecution could not include evidence related to a speech made by Johnson on the House floor because of his constitutional immunity. But, the court made clear, Johnson could be retried on the same count wholly purged of elements offensive to the speech or debate clause. ID. At 185, although his unprotected conduct constituted an official act under Fitzgerald, communicating with the executive branch, CID. At 172, it was constrained by and subject to criminal statute of general application. ID. At 185. Judges are similarly liable to the criminal laws for their official acts. A notable example is Ex parte Commonwealth of Virginia, in which the Supreme Court applied Marbury's discretionary ministerial distinction to affirm the criminal indictment of a judge based on an official act. 100 U.S. 339. A county judge was indicted in federal court for violating a federal statute that prohibited discriminating on the basis of race in jury selection. 144. The Supreme Court began by observing the principle that officers are bound to follow the law. We do not perceive how holding an office under a state and claiming to act for the state can relieve the 27 holder from obligation to obey the Constitution of the United States or take away the power of Congress to punish his disobedience. ID. At 348. The court then addressed the judge's argument that the court lacked the authority to punish a state judge for his official acts. ID. Its response was twofold. First, the court described juror selection as merely a ministerial act, as much so as the act of a sheriff holding an execution, in determining upon what piece of property he will make a levy, or the act of a roadmaster in selecting laborers to work upon the roads. In ID. The court then explained that even if juror selection is considered a judicial act, the judge had a legal duty to obey the criminal laws. But if the selection of jurors could be considered in any case a judicial act, can the act charged against the petitioner be considered such when he acted outside of his authority and in direct violation of the spirit of the state statute? That statute gave him no authority, when selecting jurors, from whom a panel might be drawn for a circuit court, to exclude all colored men merely because they were colored. Such an exclusion was not left within the limits of his discretion. It is idle, therefore, to say that the act of Congress is unconstitutional because it inflicts penalties upon state judges for their judicial action. It does no such thing. 28. More recent case law on the judicial immunity doctrine affirms that judges are not immune from criminal liability for their official acts. O'Shea v. Littleton confirmed the holding of Ex parte Virginia in dismissing a civil rights action for equitable relief brought against a county magistrate and associate judge of a county circuit. 414 U.S. 488, 490, 91, 503. The Supreme Court concluded that the requested injunction was not the only available remedy because both judges remained answerable to the federal criminal laws. Have never held that the performance of the duties of judicial, legislative, or executive officers requires or contemplates the immunization of otherwise criminal deprivation of constitutional rights. On the contrary, the judicially fashioned doctrine of official immunity does not reach so far as to immunize criminal conduct prescribed by an act of Congress. Similarly, in Dennis v. Sparks, the court affirmed judicial immunity from civil money damages in the context of bribery allegations, but explained that judges are subject to criminal prosecutions as are other citizens. 449 U.S. at 31. Crucially, the judge in Dennis retained civil immunity because the challenged conduct, allegedly issuing an injunction corruptly after accepting bribes as part of a conspiracy, was an official judicial act within his statutory jurisdiction, broadly construed. The scope of civil judicial immunity thus aligns with civil presidential immunity under Fitzgerald, but a judge has no criminal immunity for the same official act. See also Imbler farce, Pachman, 424 U.S., 409, 429. Even judges, cloaked with absolute civil immunity for centuries, could be punished. 29. Criminally for willful deprivations of constitutional rights. United States v. Gillick, 445 U.S., 360, 372. He cases in this court, which have recognized an immunity from civil suit for state officials, have presumed the existence of federal criminal liability as a restraining factor on the conduct of state officials. When considering the criminal prosecutions of judges, other circuits have repeatedly rejected judicial criminal immunity for official acts, largely in the context of bribery prosecutions. Former President Trump argues that bribery allegations were not considered judicial acts at common law. Appellants Br. 21, but his sources do not support his conclusion. He is correct that Blackstone and other early common law sources expressly contemplated the criminal prosecution of judges on bribery charges, but this shows only that judicial immunity did not stretch to shield judges from generally applicable criminal laws, not that bribery was ever considered a non-official act. And as explained supra, the Supreme Court emphasized the official nature of the bribery allegations in Dennis while reinforcing the judge's criminal liability. We therefore conclude that Article III courts may hear the charges alleged in the indictment under the separation of powers doctrine, as explained in Marbury and its progeny, and applied in the analogous contexts of legislative and judicial immunity. The indictment charges that former President Trump violated criminal laws of general applicability. Acting against laws enacted by the Congress, he exercised power that was at its lowest ebb. Former President Trump lacked any lawful discretionary authority to defy federal criminal law, and he is answerable in court for his conduct. B. Functional policy considerations. Even though it is proper under Marbury and its progeny for an Article III court to hear criminal charges brought against a former president, we necessarily must weigh concerns of public policy, especially as illuminated by our history and the structure of our government, including our constitutional heritage and structure. Fitzgerald, 457 U.S., at 747-48 CID. At 748, our historical analysis merges with public policy analysis because the presidency did not exist through most of the development of common law. Clinton, 520 U.S., at 694. Courts apply a functional approach in determining the scope. 31. Of official immunity. This inquiry involves policies and principles that may be considered implicit in the nature of the president's office in a system structured to achieve effective government under constitutionally mandated separation of powers. Fitzgerald, 457 U.S., at 748. Our analysis entails balancing the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. 4. We note at the outset that our analysis is specific to the case before us, in which a former president has been indicted on federal criminal charges arising from his alleged conspiracy to overturn federal election results and unlawfully overstay his presidential term. We consider the policy concerns at issue in this case in two respects. First, we assess possible intrusions on the authority and functions of the executive branch and the countervailing interest to be served as those concerns apply to former President Trump's claim that former presidents are categorically immune from federal prosecution. We conclude that the interest in criminal accountability, held by both the public and the executive branch, outweighs the potential risks of chilling presidential action and permitting vexatious litigation. Second, we examine the additional interests raised by the nature of the charges in the indictment. The executive branch's interest in upholding presidential elections and vesting power in a new president under the Constitution, and the voters' interests in democratically selecting their president. We find these interests compel the conclusion that former President Trump is not immune from prosecution under the indictment. 1. Categorical immunity defense. Former President Trump argues that criminal liability for former presidents risks chilling presidential action while in office and opening the floodgates to meritless and harassing prosecution. These risks do not overcome the public interest in fair and accurate judicial proceedings, which is at its height in the criminal setting. 424. Former President Trump first asserts that the prospect of potential post-presidency criminal liability would inhibit a sitting president's ability to act fearlessly and impartially, citing the especially sensitive duties of the president and the need for bold and unhesitating action. But he chanced that now and then there may be found some timid soul who will take counsel of his fears and give way to their repressive power is too remote and shadowy to shape the course of justice. In Clark, the Supreme Court dismissed the threat of a chilling effect, holding that jurors could be subject to criminal prosecution for conduct during their jury service and explaining that a juror of integrity and reasonable firmness will not fear to speak his mind if the confidences of debate are barred to the ears of mere impertinence or malice. Rather, the court observed, he will not expect to be shielded against the disclosure of his conduct in the event that there is evidence reflecting upon his honor. The court reinforced the point in United States v. Nixon, holding that it could not conclude that advisors will be moved to temper the candor of their remarks by the infrequent occasions of disclosure because of the possibility that such conversations will be called for in the context of a criminal prosecution. So too here. We cannot presume that a president will be unduly cowed by the prospect of post-presidency criminal liability. 33. More than a juror would be influenced by the prospect of post-deliberation criminal liability, or an executive aide would be quieted by the prospect of the disclosure of communications in a criminal prosecution. Moreover, past presidents have understood themselves to be subject to impeachment and criminal liability, at least under certain circumstances, so the possibility of chilling executive action is already in effect. Even former President Trump concedes that criminal prosecution of a former president is expressly authorized by the impeachment judgment clause after impeachment and conviction. We presume that every president is aware of the impeachment judgment clause and knows that he is liable and subject to indictment, trial, judgment, and punishment, according to law, at least after impeachment and conviction. Additionally, recent historical evidence suggests that former presidents, including President Trump, have not believed themselves to be wholly immune from criminal liability for official acts during her presidency. President Gerald Ford issued a full pardon to former President Richard Nixon, which both former presidents evidently believed was necessary to avoid Nixon's post-resignation indictment. Before leaving office, President Bill Clinton agreed to a 5-year suspension of his law license and a $25,000 fine in exchange for independent counsel Robert Ray's agreement not to file criminal charges against him. And during President 34. Trump's 2021 impeachment proceedings for incitement of insurrection, his counsel argued that instead of post-presidency impeachment, the appropriate vehicle for investigation, prosecution, and punishment is the Article 3 courts, as he have a judicial process and an investigative process, to which no former officeholder is immune. In light of the express mention of indictment in the impeachment judgment clause and recent historical evidence of former presidents acting on the apparent understanding that they are subject to prosecution even in the absence of conviction by the Senate, the risk of criminal liability chilling presidential action appears to be low. Instead of inhibiting the president's lawful discretionary action, the prospect of federal criminal liability might serve as a structural benefit to deter possible abuses of power and criminal behavior. Where an official could be expected to know that certain conduct would violate statutory or constitutional rights, he should be made to hesitate. As the district court observed, every president will face difficult decisions. Whether to intentionally commit a federal crime should not be one of them. Former President Trump next urges that a lack of criminal immunity will subject future presidents to politically motivated prosecutions as soon as they leave office. In the civil context, the Supreme Court found official act presidential immunity necessary in part to avoid subject the president to trial on virtually every allegation that an action was unlawful, or was 35. Taken for a forbidden purpose, Fitzgerald, 457 U.S., at 756 CID, at 753, in view of the visibility of his office and the effect of his actions on countless people, the president would be an easily identifiable target for suits for civil damages. But the decision to initiate a federal prosecution is committed to the prosecutorial discretion of the executive branch. Prosecutors have ethical obligations not to initiate unfounded prosecutions, and courts presume that they properly discharge their official duties. United States v. Armstrong, 517 U.S., 456, 464. Quoting United States v. Chem. Found, Inc., 272, U.S., 1, 14, 15. There are additional safeguards in place to prevent baseless indictments, including the right to be charged by a grand jury upon a finding of probable cause. U.S. Const. Amend. v. Cayley v. United States, 571, U.S., 320, 328. Grand juries are prohibited from engaging in arbitrary fishing expeditions and initiating investigations out of malice or an intent to harass. Vance, 140 seconds, CT, at 2,428, quoting United States v. R. Enters, Inc., 498 U.S., 292, 299. Additionally, former President Trump's predictive judgment of a torrent of politically motivated prosecutions finds little support in either history or the relatively narrow compass of the issues raised in this particular case. See Clinton, 520 U.S., at 702, as former President Trump acknowledges that this is the first time since the founding that a former president has been federally indicted. Weighing these factors, we conclude that the risk that former presidents will be unduly harassed by meritless federal criminal prosecutions appears slight. On the other side of the scale, we must consider the constitutional weight of the interest to be served by allowing the prosecution of a former president to proceed. 754. The public has a fundamental interest in the enforcement of criminal laws. At 2,424, our historic commitment to the rule of law is nowhere. 36. More profoundly manifest than in our view that the twofold aim of criminal justice is that guilt shall not escape or innocence suffer. Nixon, 418 U.S., at 708, quoting Berger v. United States, 295 U.S. 78, 88. As the Nixon court explained, wholly immunizing the president from the criminal justice process would disturb the primary constitutional duty of the judicial branch to do justice in criminal prosecutions to such an extent that it would undermine the separation of powers by plainly conflict with the function of the courts under Art. Third, Nixon. There is also a profound Article II interest in the enforcement of federal criminal laws. The president has a constitutionally mandated duty to take care that the laws be faithfully executed. As part of this duty, the president is responsible for investigating and prosecuting criminal violations. See Morrison Farr, Olson, 487, U.S. 654. For creative nonviolence for Pierce, 786 Fahrenheit, 1,199, 1,201. The power to decide when to investigate and when to prosecute lies at the core of the executive's duty to see to the faithful execution of the laws. Beyond simply making explicit that a president must enforce the law, The Take Care Clause plays a central role in signify the principle that ours is a government of laws, not of men, and that we submit ourselves to rulers only if under rules. Youngstown, it would be a striking paradox if the president, who alone is vested with the constitutional duty to take care, 37, that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity. The federal prosecution of a former president fits the case. Hen judicial action is needed to serve broad public interests in order to vindicate the public interest in an ongoing criminal prosecution. The risks of chilling presidential action or permitting meritless, harassing prosecutions are unlikely, unsupported by history, and too remote and shadowy to shape the course of justice. We therefore conclude that functional policy considerations rooted in the structure of our government do not immunize former presidents from federal criminal prosecution. 2. Immunity from the indictments. Charges. In addition to the generally applicable concerns discussed supra, the allegations of the indictment implicate the Article 2 interests in vesting authority in a new president and the citizenry's interest in democratically selecting its president. The indictment alleges that the assertedly official actions at issue here were undertaken by former President Trump in furtherance of a conspiracy to unlawfully overstay his term as president and to displace his duly elected successor. That alleged conduct violated the constitutionally established design for determining the results of the presidential election as well as the Electoral Count Act of 1887, neither of which establishes a role for the president in counting and certifying the Electoral College votes. The alleged conduct also violated Article 2's mandate that a president hold his office during the term of 4 years. 38. U.S. Const. Art. 2. The 20th Amendment reinforces the discrete nature of a presidential term, explicitly providing that the terms of the president and vice president shall end at noon on the 20th day of January, and the terms of their successors shall then begin. Upon the expiration of the time for which he is elected, a former president returns to the mass of the people again, and the power of the executive branch vests in the newly elected president. 1. CL. 1. The executive power shall be vested in a president of the United States of America. Emphasis added. The president, of course, also has a duty under the Take Care Clause to faithfully enforce the laws. This duty encompasses following the legal procedures for determining election results and ensuring that executive power vests in the new president at the constitutionally appointed time. To the extent former President Trump maintains that the post-2020 election litigation that his campaign and supporters unsuccessfully pursued implemented his take care duty, he is in error. Former President Trump's alleged conduct conflicts with his constitutional mandate to enforce the laws governing the process of electing the new president. The public has a strong interest in the foundational principle of our government, that the will of the people, as expressed in the Electoral College vote, determines who will serve as president. The Supreme Court recently noted that the framers made the president the most 39. Democratic and politically accountable official in government, the only one who, along with the vice president, is elected by the entire nation. Selah Law LLC v. Consumer Fin. Brat. Bureau, 140 seconds. CT, 2183, 2203. To justify and check the president's unique in our constitutional structure, Article 2 render the president directly accountable to the people through regular elections. ED. As James Madison put it, dependence on the people is, no doubt, the primary control on the government. The Federalists No. 51, at 253, James Madison 9. See also Morrison, 487 U.S., at 731, Scalia, J. Dissenting. He founders established a single chief executive accountable to the people so that the blame be assigned to someone who can be punished. Thus, the quadrennial presidential election is a crucial check on executive power because a president who adopts unpopular policies or violates the law can be voted out of office. Former President Trump's alleged efforts to remain in power despite losing the 2020 election were, if proven, an unprecedented assault on the structure of our government. He allegedly injected himself into a process in which the president has no role, the counting and certifying of the Electoral College votes, thereby undermining constitutionally established procedures and the will of the Congress. To immunize former President Trump's actions would further aggrandize the presidential office, already so potent and so relatively immune from judicial review, at the expense of Congress. As Justice Jackson warned, executive power has the advantage of concentration in a single head in whose choice the whole nation has a part, making him the focus of public hopes and expectations. In drama, magnitude and finality, his decisions so far overshadow any others that almost alone he fills the public eye and ear. No other personality in public life can begin to compete with him in access to the public mind through modern methods of communications. By his prestige as head of state and his influence upon public opinion, he exerts a leverage upon those who are supposed to check and balance his power, which often cancels their effectiveness. Concurring, we cannot accept former President Trump's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results. Nor can we sanction his apparent contention that the executive has carte blanche to violate the rights of individual citizens to vote and to have their votes count. At bottom, former President Trump's stance would collapse our system of separated powers by placing the president beyond the reach of all three branches. Presidential immunity against federal indictment would mean that, as to the president, the Congress could not legislate, the executive could not prosecute, and the judiciary could not review. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. Careful evaluation of these concerns leads us to conclude that there is 41. No functional justification for immunizing former presidents from federal prosecution in general or for immunizing former President Trump from the specific charges in the indictment. In so holding, we act, not in derogation of the separation of powers, but to maintain their proper balance. 754. C. The Impeachment Judgment Clause. The strongest evidence against former President Trump's claim of immunity is found in the words of the Constitution. The Impeachment Judgment Clause provides that judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. U.S. Const. Art. I. 3. CL. 7. That language limits the consequences of impeachment to removal and disqualification from office, but explicitly preserves the option of criminal prosecution of an impeached official according to law. Former President Trump agrees that the Impeachment Judgment Clause contemplates and permits the prosecution of a former president on criminal charges. He argues only that such a former president first must be impeached by the House and convicted by the Senate. In other words, he asserts that, under the clause, a former president enjoys immunity for any criminal acts committed while in office unless he is first impeached and convicted by the Congress. Under that theory, he claims that he is immune from prosecution because he was impeached and acquitted. By taking that position, former President Trump potentially narrows the party's dispute to whether he may face criminal charges in this case consistent with the impeachment judgment. 42. Clause. If the clause requires an impeachment conviction first, he may not be prosecuted, but if it contains no such requirement, the clause presents no impediment to his prosecution. Former President Trump also implicitly concedes that there is no absolute bar to prosecuting assertedly official actions. He argues elsewhere in his brief that his impeachment on the charge of inciting insurrection was based on conduct that was the same and closely related to the official acts charged in the indictment. 46. President Trump was impeached and acquitted by the Senate for the same and closely related conduct to that alleged in the indictment. At 42, all 5 types of conduct alleged in the indictment constitute official acts. And he agrees that if he had been convicted by the Senate in that impeachment trial, he would not be immune from prosecution for the official acts at issue here. Thus, he concedes that a president can be prosecuted for broadly defined official acts, such as the ones alleged in the indictment, under some circumstances, i.e., following an impeachment conviction. The Impeachment Judgment Clause is focused solely on those who are convicted by the Senate following impeachment by the House. The first part of the clause limits the penalties that can be imposed based on an impeachment conviction. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. L. 7. The second part makes clear that the limited consequences of impeachment do not immunize convicted officers from criminal prosecution. He party convicted shall nevertheless be liable and subject. 43. To indictment, trial, judgment, and punishment according to law. In former President Trump's view, however, the word convicted in the second phrase implicitly bestows immunity on presidents who are not convicted, based on a negative implication. He asserts that the impeachment judgment clause presupposes that a president is not criminally liable absent a conviction in the Senate. Other courts have rejected this tortured interpretation of the impeachment judgment clause, which previously has been advanced to support claims of judicial immunity. See Claiborne, 727 Fahrenheit, at 846, according to Claiborne. This language means that a federal judge cannot be indicted and tried in an Article III court unless he has been removed from office by the impeachment process. Both Isaacs and Hastings rejected this tortured interpretation. Cleaned up, Hastings, 681F, at 710, Isaacs, 493F, at 1142. The impeachment judgment clause does not mean that a judge may not be indicted and tried without impeachment first. Moreover, former President Trump's interpretation runs counter to the text, structure, and purpose of the impeachment judgment clause. See NLRB v. SW Gen. Inc. 580 U.S. 288, 302. The force of any negative implication depends on context and applies only when circumstances support a sensible inference that the term left out must have been meant to be excluded. Cleaned up, Mercy Hosp, Inc. v. Azar, 891 Fahrenheit, 1062, 1069. Finding the negative implication of a statute is a context-specific exercise. To begin, former President Trump's reliance on a negative implication is an immediate red flag. The framers knew how to explicitly grant criminal immunity in the Constitution, as they did to legislators in the speech or debate clause, yet they chose not to include a similar 44 provision granting immunity to the president. See Vance, 140 seconds, CT, at 2434, Thomas, J. Dissenting. The text of the Constitution explicitly addresses the privileges of some federal officials, but it does not afford the president absolute immunity. The impeachment judgment clause merely states that the party convicted shall nevertheless be subject to criminal prosecution. The text says nothing about non-convicted officials. Former President Trump's reading rests on a logical fallacy. Stating that if the president is convicted, he can be prosecuted does not necessarily mean that if the president is not convicted, he cannot be prosecuted. See e.g. NLRB v. Noah Canning, 573 U.S., 513, 589, Scalia, J. Concurring, explaining the fallacy of the inverse, otherwise known as denying the antecedent, the incorrect assumption that if P implies Q, then not P implies not Q. Another important clue is the clause's use of the word nevertheless, as in the party convicted shall nevertheless be liable. The meaning of nevertheless, according to a contemporaneous 18th century dictionary, is notwithstanding that, which in turn means without hindrance or obstruction from. 2. The impeachment judgment clause contains no words that limit criminal liability, and, to the contrary, it uses nevertheless to ensure that liability will not be limited, i.e., hindered or obstructed, even after an official is impeached, convicted, and removed from office. The text of the impeachment judgment clause reflects its purpose, to allocate responsibility between the legislative and executive branches for holding impeached officers accountable for misconduct. In February 18, 2024 to Century Great Britain, impeachment could result in capital punishment, fine and ransom or imprisonment. 2. Joseph Story. Commentaries on 45. The Constitution of the United States 782. The framers chose to withhold such broad power from the Senate, specifying instead that the Senate could impose only political, not ordinary criminal, punishments. OLC Double Jeopardy Memo at 124. See also Tench Cox, an American citizen, Independent Gazetteer, Philadelphia, Sept. February 28, 1787. The Senate can only, by conviction on impeachment, remove and incapacitate a dangerous officer. Emphasis in original. That approach naturally raised the question whether the other punishments the founding generation was accustomed to seeing in British impeachment proceedings could be imposed at all under the new American government. The framers wished to make clear that a president would still be liable to prosecution and punishment in the ordinary course of law. The Federalist, No. 65, at 321, Alexander Hamilton, Hux, an American citizen, he punishment of as a criminal remains within the province of the courts of law to be conducted under all the ordinary forms and precautions. Emphasis in original. They therefore added the provision that the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment, according to law. As the Office of Legal Counsel noted, that second part makes clear that the restriction on sanctions in the first part was not a prohibition on further punishments. Rather, those punishments would still be available, but simply not to the OL. In short, then, the framers, 46, intended impeached officials to face criminal liability according to law. To counter the historical evidence that explains the purpose of the impeachment judgment clause, former President Trump turns to one sentence written by Alexander Hamilton in the Federalist. The President of the United States would be liable to be impeached, tried, and upon conviction of treason, bribery, or other high crimes or misdemeanors, removed from office, and would afterwards be liable to prosecution and punishment in the ordinary course of law. Hamilton. He focuses on the word afterwards and suggests that a president is not liable to prosecution and punishment until after he has been impeached and convicted by the Senate. But we think the more significant word in Hamilton's statement is liable, which means subject to. Liable. 1 John Ashe, New and Complete Dictionary of the English Language. Hamilton specifies that a president would be subject to impeachment, trial, conviction, and removal from office, and afterwards would be subject to prosecution and punishment, without regard to the verdict in the impeachment proceeding. Moreover, in the very next sentence of the same essay, Hamilton stresses that the president must be unlike the King of Great Britain, who was sacred and inviolable. The Federalist, No. 69, at 337-38. It strains credulity that Hamilton would have endorsed a reading of the impeachment judgment clause that shields presidents from all criminal accountability unless they are first impeached and convicted by the Congress. Other historical evidence further supports our conclusion. For example, many founding-era sources state that an impeached and acquitted official may face criminal indictment and trial. Edmund Pendleton, president of the Virginia Ratifying Convention, noted that Senate obstruction of an impeachment charge would not allow an official to escape accountability because the people may yet resort to the courts of justice, as an acquittal would not bar that remedy. Similarly, James Wilson, a member of the Constitutional Convention Committee that drafted the impeachment judgment clause, argued as follows: though may not be convicted on impeachment before the Senate, they may be tried by their country, and if their criminality is established, the law will punish. A grand jury may present, a petit jury may convict, and the judges will pronounce the punishment. In drafting the impeachment judgment clause, to the extent that the framers contemplated whether impeachment would have a preclusive effect on future criminal charges, the available evidence suggests that their intent was to ensure that a subsequent prosecution would not be barred. COLC Double Jeopardy Memo at 122, noting limited scope of 48. Discussion at the Constitutional Convention and ratifying conventions regarding the impeachment judgment clause. Joseph Story explained that the impeachment judgment clause removed doubt that a second trial for the same offense could be had, either after an acquittal or a conviction in the Court of Impeachments, 781, noting the Constitution has wisely subjected the party to trial in the common criminal tribunals for the purpose of receiving such punishment as ordinarily belongs to the offense. Story explained that without a criminal trial, the grossest official offenders might escape without any substantial punishment, even for crimes which would subject their fellow citizens to capital punishment. Finally, the practical consequences of former President Trump's interpretation demonstrate its implausibility. The impeachment judgment clause applies not just to presidents but also to the vice president and all civil officers of the United States. Thus, his reading would prohibit the executive branch from prosecuting current and former civil officers for crimes committed while in office, unless the Congress first impeached and convicted them. No court has previously imposed such an irrational impeachment first constraint on the criminal prosecution of federal officials. 12. Even if there isn't a textual basis for treating presidents differently from subordinate government officials, as former President Trump suggests. His proposed interpretation still would leave a president free to commit all manner of crimes with impunity, so long as he is not impeached and convicted. Former President Trump's interpretation also would permit the commission of crimes not readily categorized as impeachable, i.e., as treason, bribery, or other high crimes and misdemeanors, and, if 30 senators are correct, crimes not discovered until after a president leaves office. Statement of Senate Minority Leader McConnell, "We have no power to convict and disqualify a former officeholder who is now a private citizen." 13 all of 12. This leads us to conclude that, under the best reading of the impeachment judgment clause, a former president may be criminally prosecuted in federal court, without any requirement that he first be impeached and convicted for the same conduct. Fourth, double jeopardy principles. Former President Trump alternatively argues that the impeachment judgment clause and principles of double jeopardy bar his prosecution because he was impeached by the House of Representatives for the same or closely related conduct, but acquitted by the Senate. We disagree. As we have discussed, supra part the third does say, the impeachment judgment clause addresses only convicted parties. It does not address the consequences of a Senate acquittal. For the reasons already stated, the clause's provision that the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment, according to law, does not bar the prosecution of an official who, like former President Trump, was acquitted rather than convicted in an impeachment proceeding, nor does it bar the prosecution of an official who was never impeached in the first place. 7. The clause simply does not speak to such matters. But the weight of historical authority indicates that the framers intended for public officials to face ordinary criminal prosecution as well as impeachment. To the extent former President Trump relies on double jeopardy principles beyond the text of the impeachment judgment clause, those principles cut against him. The double jeopardy clause provides, "No person shall be subject for the same offense to be twice put in jeopardy of life or limb." Fifth, it has been interpreted to prohibit imposition of multiple criminal punishments for the same offense. Under precedent interpreting the double jeopardy clause, former President Trump's impeachment acquittal does not bar his subsequent criminal prosecution for two reasons. An impeachment does not result in criminal punishments, and the indictment does not charge the same offense as the single count in the impeachment resolution. 52. A impeachment is not criminal. Under the double jeopardy clause, a defendant is not put in jeopardy of life or limb, U.S. Const. Amend. V. When faced with any penalty that could, in common parlance, be described as punishment. Instead, double jeopardy guards only against imposition of multiple criminal punishments for the same offense. Although double jeopardy applies only to criminal punishments, impeachment imposes political punishments. Impeachment is a political process that is instigated and overseen by the Congress. C2 story, commentary 784, there is wisdom and sound policy and intrinsic justice in this separation of the offense, at least so far as the jurisdiction and trial are concerned, into its proper elements, bringing the political part under the power of the political department of the government. Emphasis added. 9 Annal 2475, Statement of Rep. Dana, the process in cases of impeachment in this country is distinct from either civil or criminal. It is a political process, having in view the preservation of the government of the Union. It is a tool entrusted to elected officials and designed to enable Congress to protect the nation against officers who have demonstrated that they are unfit to carry out important public responsibilities. OLC Double Jeopardy Memo at 130. See the Federalist, No. 66. At 324, Alexander Hamilton, powers relating to impeachments are, as before intimated, an essential check in the hands of upon the encroachments of the executive. The consequences imposed by an impeachment conviction, removal from office and disqualification from future service. 53. U.S. Const. Art. I. Are intended to hold officials politically accountable, while leaving criminal accountability to the judicial branch. As a result of the political nature of impeachment proceedings, impeachment acquittals are often unrelated to factual innocence. See the Federalist, No. 65. At 319, in an impeachment proceeding, there will always be the greatest danger that the decision will be regulated more by the comparative strength of parties than by the real demonstrations of innocence or guilt. Former President Trump's acquittal in his impeachment trial on the charge of inciting insurrection makes this point. The 43 senators who voted to acquit him relied on a variety of concerns, many of which had nothing to do with whether he committed the charged offense. Those senators cited jurisdictional reasons. See, e.g., 167 Cong. Rec. S. Statement of Senate Minority Leader McConnell. We have no power to convict and disqualify a former officeholder who is now a private citizen. Process-based reasons. See, e.g., press release. Sen. Todd Young. Senator Young's statement on impeachment trial. Simply put, the U.S. House of Representatives conducted a rushed and incomplete process for this snap impeachment. And political reasons? See, e.g., press release. Sen. Ron Johnson. Johnson's statement on impeachment trial of former President Trump. The Democrats' vindictive and divisive political impeachment is over. While there are still many questions that remain unanswered, I do know neither the Capitol breach nor this trial should have ever occurred. Hopefully, true healing can now begin. Indeed, at least 30 senators who voted to acquit relied at least in part on a belief that the Senate lacked the power to convict a former president. See Supra 54. Criminal prosecutions, by contrast, are aimed at penalties individuals for their criminal misdeeds. By taking away their life, liberty, or property, the consequences of a criminal conviction are predicated on a finding of guilt beyond a reasonable doubt. United States v. Goding, 515 U.S. 506, 510, and such consequences can be severe, including asset forfeiture, incarceration, and even death. Criminal prosecutions are overseen by the judiciary, which enforces stringent procedural protections that reflect the gravity of the potential ramifications for the defendant. See Nixon, 418 U.S. at 707, describing the primary constitutional duty of the judicial branch to do justice in criminal prosecutions. The Double Jeopardy Clause is one such procedural protection, ensuring that a criminal defendant is not forced to face prosecution twice for the same offense. In light of the very different procedures and purposes associated with impeachment proceedings as compared to criminal proceedings, former President Trump's reliance on the Double Jeopardy Clause is misplaced. Impeachment is not a criminal process and cannot result in criminal punishment. He does not seriously contend otherwise, and he does not explain why he believes that impeachment can implicate double jeopardy principles when it does not involve criminal punishment. B. Blockburger test. Even if we assume that an impeachment trial is criminal under the Double Jeopardy Clause, the crimes alleged in the indictment differ from the offense for which President Trump was impeached. In determining whether two charges are the same for double jeopardy purposes, courts apply the sum elements test, also known as the Blockburger test. If each offense contains an element not contained in the other, the offenses are different. If the charges at issue are not the same offense under that test, double jeopardy does not bar prosecution. 7. Under the Blockburger test, none of the four offenses alleged in the indictment is the same as the sole offense charged in the article of impeachment. The indicted criminal counts include conspiracy to defraud the United States under 18 U.S.C. 371, conspiracy to obstruct and obstructing an official proceeding under 18 U.S.C. and conspiracy to deprive one or more individuals of the right to vote under U.S.C. See Indictment 6, 126, 128, 130. By contrast, the article of impeachment charged former President Trump with incitement of insurrection. Each of the indicted charges requires proof of an element other than those required for incitement, and the offense of incitement of insurrection requires proof of incitement, an element that is distinct from those associated with each of the crimes of indictment. In other words, the charges are not the same under a straightforward application of the Blockburger test. Former President Trump does not dispute this analysis, and instead contends that, rather than applying the Blockburger test, a subsequent criminal prosecution cannot be based on the same or closely related conduct as an unsuccessful impeachment. But that argument is foreclosed by case law. The same conduct rule is wholly inconsistent with Supreme Court precedent and with the clear common law understanding of double jeopardy. Dixon, 509 U.S. at 704. See also Hudson, 522 U.S. at 107. Stevens, J. Concurring in the judgment, He double jeopardy clause is not implicated simply because a criminal charge involves essentially the same conduct for which a defendant has previously been punished. Cleaned up. Thus, well-established law interpreting the double jeopardy clause undermines, rather than supports former President Trump's argument that he may not be prosecuted. Perhaps recognizing that normal double jeopardy rules disfavor his position, he claims that the impeachment judgment clause incorporates double jeopardy principles that are distinct from the double jeopardy clause. See Appellant's BR 54N. But if the double jeopardy principles he invokes are unmoored from the double jeopardy clause, we are unable to discern what the principles are or how to apply them. He thus fails to establish that his Senate acquittal bars his criminal prosecution. 57. We have balanced former President Trump's asserted interests in executive immunity against the vital public interests that favor allowing this prosecution to proceed. We conclude that on concerns of public policy, especially as illuminated by our history and the structure of our government, compel the rejection of his claim of immunity in this case. C. Fitzgerald, 457 U.S. at 747, 48. We also have considered his contention that he is entitled to categorical immunity from criminal liability for any assertedly official action that he took as president, a contention that is unsupported by precedent, history, or the text and structure of the Constitution. Finally, we are unpersuaded by his argument that this prosecution is barred by double jeopardy principles. Accordingly, the order of the district court is affirmed. So ordered. 16 amici.
All right, let's just hear that last bit again.
So ordered. 16 amici.
Yeah, nice. Well, thank you for coming on this journey with me. This was a lot harder than the last one we listened to, which was a bunch of historians telling a really nice and interesting and sometimes really disturbing tale of the willingness, or just the way that, like, Civil War, white people clung to their racism, like, especially in the South. Not saying the North didn't have problems, but oh my gosh, just the desire to own people and to have this racial superiority. But anyway, this was way denser. Obviously, you can see why it took the justices a little longer to write it out. So someone in the chat, I think it was at Orion, asked what are the next steps, or somebody did. And from my understanding, Trump, well, one thing is, I think the court says something along the lines of somewhere that basically if there is nothing done by a certain date, this gets kicked back down. So the steps now, so that's one thing that's kind of in play. I think by the 15th, Trump has to reply based on the news reporting I saw. I think it was on CNN while I was on my bike. And then Trump can request an en banc, which would be a full hearing of all of the justices on the appellate court in the DC circuit, which I think are 11, might be 9. Anyway, this was 3, and then it would go to the full court. He would need 4 votes for yes, so maybe it is 9. I don't know. Anyway, I'm not a lawyer. And then whatever happens at the, if they do get an en banc hearing and there's a decision there, Trump could appeal to the Supreme Court. Now, the Supreme Court does not need to take this case up. They've already looked at immunity a couple times. They might just let this stand. It would be interesting for me to see if the DC appellate, like the full court, even bothers with this, considering the sort of time-sensitive nature of things in Judge Chutkan's court. So that is where we currently stand. Again, I am not a lawyer. Do not take legal advice from me. And if someone who has a law degree corrects me on any of those details, believe them. I'm still hoping tomorrow to get to the Littman, friend of the court filing. Yeah, and so that will be interesting. I'll see if I can get that done. I think I can just go to camera now. I'm a mess. I need to go have a shower. I need to sort my life out. Get some dinner in me. I haven't eaten since about like 4 o'clock. So I'm going to go do those things. But if I'm super motivated, then tomorrow, see you with the happy hour, otherwise Thursday. You might be getting more live streams. I don't know if you're enjoying this. This might be a very niche product. But for those nerds out there who want to, passively take in the information without having to go find the PDF and downloading it themselves, Thank you for coming on this journey with me. Thank you for everyone in the chat. I see Orion. I see Alistair. I see like someone whose name I can't because it's very tiny. Who are? Let me see. Who are you? Who are you in the chat? Bowler Hatman is there as well. So thank you, John Henry. Definitely helps. To see your comments actually kind of freaks me out because I'm like, oh, what are they saying? But I'm gonna go. Like I said, I'm gonna go work out now. Y'all have a great night. I've been Christy. You've been awesome. Have a great day, great evening, great afternoon, wherever it is and whenever it is that you are. And until next time, which might be sooner than you think, I've been Christy. You've been awesome. I'll catch you later.